One of the strongest defenses against deportation, if a person can meet this criteria, is called cancellation of removal. This is a kind of defense that a person in immigration court removal proceedings can use to defend themselves against deportation. And there's a few items I want to go over about this type of request for relief with an immigration judge. My name is Larissa Davis. I'm an immigration attorney with Chabra Gibson Trahan in Jackson, Mississippi, and I'm licensed to practice before all U.S. immigration courts nationwide. Okay, so for 42B, cancellation of removal, this is not a application a person can just file with USCIS. This is something that is a defense in immigration court before an immigration judge to try to get relief from the court from removal. Another word for removal that people commonly use is deportation, so being deported from the United States. So there are three main parts to this type of relief that a person has to prove to the immigration court. All right, the first one is that they've been in the United States for at least 10 years. So proving the 10 years of physical presence could mean showing taxes were filed and paid, lease agreements or property ownership, different types of records. If a person's been in the United States for at least 10 years and they can show it through those records, that's just the first part. All three have to be met, not just one or two, all three. Okay, the second thing is that the person is of good moral character. So that means they don't have any issues with law enforcement. They haven't been arrested or charged with any crimes. All right, this last one is probably the most challenging for people to meet or to prove to the court, because maybe they've been here for at least 10 years, they're of good moral character, they've followed the laws, but if they cannot show this to the court, then they're going to have a really difficult time winning in immigration court to get that cancellation of removal relief. And that is that they have a U.S. citizen or lawful permanent resident, child, spouse, or parent who would suffer exceptional and extremely unusual hardship. So this is a high standard to try to prove to the court. It's not enough that the person would just be emotionally or mentally having a difficult time, or that the U.S. citizen dependent child or spouse or parent would have a difficult time with that separation. You have to prove that it's going to be an exceptional or extremely unusual hardship. So for example, if a person has a U.S. citizen child with medical issues, health conditions, maybe a disabled child or spouse or parent that is a U.S. citizen, then we have to show that hardship to that U.S. citizen or green card holder. It is not for the person in removal proceedings, it's that this U.S. citizen, child, spouse, or parent would suffer that extreme or unusual hardship. It's important to get an immigration attorney in immigration court removal proceedings. There's a lot of steps and different information and documents that have to timely be filed with the court to prove that a person is eligible for this relief. If you would like to speak with me about your immigration matter and you think you might be eligible for cancellation of removal or maybe a different type of relief, you can contact us at 601-927-8430. We can schedule a consultation and talk to you about what your options might be.